Hello and welcome to Protection of Employers' Confidential Information, presented by Schiff Hardin. We are pleased that you've decided to join us for this important topic. A copy of the presentation can be found in the Handouts section located on the left-hand side of your screen. Questions can be submitted at any time by using the chat feature in the lower left-hand corner of your screen. If time allows, our speakers will answer the questions at the conclusion of today's presentation. If we run out of time, the speakers will follow up after the presentation to answer your questions. I would now like to introduce today's speakers, Julie Starr and Matt Pruitt. Welcome, Julie and Matt. The floor is yours.
Thank you, Tammy, and hello, everybody, and thank you for joining us today. I'm Julie Starr, and some of you might know I'm a partner in the Labor and Employment Group in Chicago here at Schiff Hardin. And we have joining us today as my co-presenter Matt Pruitt, who is chair of Schiff Hardin's Cybersecurity and Data Privacy team and also co-chairs the firm's Trade Secret and Employee Mobility team. The presentation today will consist of three main topics. The first will be discussing developments in the law pertaining to trade secrets and some recent things that have been happening at the federal level. Second, we'll turn to some of the tools and practices that are available for employers to implement that will help develop and protect the rights in their confidential information and trade secrets. And then finally, we'll have a discussion at the end about some ways to try and get employee buy-in in terms of implementing and using these tools with what I know can sometimes be viewed as an off-putting set of rules and processes. So for now, I'll turn this over to Matt, who will lead us off by talking about the Federal Defense of Trade Secrets Act.
Thanks, Julie. So the big news this year in the law of trade secrets, of course, is new legislation that was enacted and officially took effect this summer, and it was several years in the making. It's the Defend Trade Secrets Act, and for those of you who have been following this legislation, it bounced around in the House and the Senate over several years through several attempts to have the statute enacted, and Congress finally got the legislation through this year. The main benefit that comes for trade secret owners from the Defend Trade Secrets Act is simply having a federal cause of action. And that may be surprising to some folks who, of course, think about the basic buckets of intellectual property law, patent law, trademark, copyright. Those have long been the subject of federal legislation and are creatures, primarily of federal law. And trade secret law has been different for a long time. Until recently, trade secret law was mostly the product of common law. Then, over a period of a couple of decades, the Uniform Trade Secrets Act was adopted in most states, and then now has been enacted in almost all states in the United States. And then there was some federal legislative activity over the past several years to protect trade secrets, but it was all in the criminal context, or almost all in the criminal context. And you'll see in our first slide here that we describe the Defend Trade Secrets Act as an amendment to the Economic Espionage Act, and that being, one of the best examples of a prior federal statute that did a lot to protect trade secrets, but only with criminal sanctions and criminal proceedings available, through the U.S. Attorney. The Defend Trade Secrets Act is engrafted onto the Economic Espionage Act and opens a federal cause of action for trade secret misappropriation. You can tell as we go through the statute in some of the key provisions, and we'll do that in just a moment, that this is a statute that was the product of a lot of thought, which I think is a good thing, and then another good thing is that it is the product of an attempt to balance a lot of competing interests. There was a lot of debate about the statute, and particularly how it would impact the rights of employees and the rights that employees have under state law. So we can see in a couple of places where the Congress eventually enacted a statute that was much more protective of employees than the first version of this legislation as it was originally proposed a few years ago. The first of those protections is was noted here on our slide that you have in front of you, which is that the statute does not expressly does not preempt state law. Injunctions under the Defend Trade Secrets Act may not conflict with applicable state law prohibiting restraints on the practice of a lawful profession, trade, or business. And that is intended to preserve intact whatever state law protections there are, limiting especially the enforcement of non-compete covenants to the extent that some creative advocate might try to engraft the law of non-competes under the new Defend Trade Secrets Act. That's especially relevant for states like California that have very strong employee protections. Another important protection for employees is that the statute, again, expressly disavows the inevitable disclosure doctrine, so that, and again, we've quoted the relevant language here, certainly there may be preliminary injunctions granted under the Defend Trade Secrets Act in the, similar to the way that preliminary injunctions would be enacted under the Uniform Trade Secrets Act is enacted in most states. And that includes an injunction to prevent a threatened misappropriation by an employee. But to make clear that does not include this, the idea of inevitable disclosure, the statute specifies that a threatened misappropriation has to be based on actual evidence and not merely on the knowledge that the person knows. In other words, it's not enough to go into court and say, well, the knowledge that our company's former employee has virtue of the work that he did for us is so similar and so closely related to the work that he's doing for the competitor who is now employing him that it is inevitable that he or she will disclose our trade secrets. That's the inevitable disclosure doctrine, and this statute makes it clear that something more than that's required. The more than that would be something a lot like evidence of misconduct that shows an intent to misappropriate the trade secrets, like mass copying of files on the way out the door, engaging in other sorts of specific prohibited activity that evidence a bad intent and bad plans. One enhanced remedy that the statute provides for trade secret owners that was the subject of extensive debate in Congress, and it remains to be seen how often it is actually employed in practice, is a new statutory procedure for ex parte seizure orders. And for those of you who have experience in practicing under federal law dealing with counterfeit goods and gray market goods, you may be familiar with some of these ex parte seizure orders that are available under other federal statutes, and that were used at least roughly as a guide for the ex parte process that is under the Defend Trade Secrets Act. Because it was the subject of extensive debate, the Congress ended up putting in a lot of safeguards and a lot of restrictions and a lot of hurdles to jump through in order to get one of these ex parte orders. So I have not gone through the process yet of having to do one of these, at least under the Defend Trade Secrets Act. And it's going to be very interesting to see how in practice the federal courts apply the pretty strict limitations that are set out in the statute. I mean, right off the bat, the statute makes it clear that these should be granted only in limited circumstances, by saying expressly that they should be granted only in extraordinary circumstances, and that's the language of the statute. Putting a little bit of meat on that bone, the statute then goes on to specify that there needs to be a clear risk that either the destruction of the trade secret or the public dissemination of the trade secret must be imminent if prior notice of the application to the court for relief is given to the defendant. some other safeguards that are provided here. Instead of having the plaintiff take custody of the seized trade secret materials, the court has to retain custody. Although the court can appoint a special master to assist with the court's exercise of its responsibility to act as a custodian of the seized materials. And then there are various safeguards that I think are very interesting in terms of maintaining data security for electronic information that is seized. So the statute specifies that if the trade secrets are maintained on some type of electronic data on some type of electronic storage device, that the trade secret information and the device that the trade secret information is stored upon must be kept separate from any connection to the internet or to a computer network. In other words, it has to be kept on a freestanding device. And then further, the defendant, the person from whom the trade secret is seized, can request encryption, and there are other restrictions on access to the information as well. And then, of course, as you might expect, the plaintiff is required to provide a bond, and the statute expressly provides that the amount of the bond is not a limitation on the amount of damages that the plaintiff may be subject to third parties in the event that the seizure order turns out to have been wrongfully issued. So I think the sort of high-level summary of this new provision for ex parte seizure orders is that it's an interesting procedure. I think that in those really extraordinary circumstances where this type of remedy is appropriate, folks will be glad that there is a statutory procedure mapped out here that exists and gives the court clear guidelines on how to carry out this relief. But I think that in terms of its impact on the day-to-day practice of trade secret lawyers and employment lawyers, that it's going to be pretty limited in its application. One point that I do think is interesting that may have broader impact here is the statute's explicit recognition of the need for specific types of safeguards against the inadvertent loss or hacking or theft of the data once it's in the custody of the court. We talked about how the statute requires that the electronic data not be put on an internet-connected or network-connected device. I can imagine in my own practice, and I've already done this, pointing to the requirements of the Defend Trade Secrets Act here for support for the argument that similar types of protections or safeguards are appropriate to include in protective orders regarding discovery of trade secret information and other types of situations where a trade secret is being compelled to be turned over pursuant to some type of compulsory legal process, without the consent of the party owning or holding the trade secret. A couple of other protections for employees that are significant potentially in the Defend Trade Secrets Act. I think that this is not a radical change in the existing law, but it's nice to see it codified and confirmed in a statute. The Trade Secrets Act, the Defend Trade Secrets Act, now expressly provides that an employee cannot be held liable for disclosing trade secrets in a couple of specific circumstances. One, if the employee is disclosing those trade secrets solely in a whistleblower function to report suspected violations of law to government officials or to an attorney, for disclosures that are made in a lawsuit or other proceeding if they're under seal, and then if the trade secrets need to be disclosed in the context of an employee's suit for retaliatory discharge or similar retaliation, but again with appropriate precautions by the employee to ensure the broader dissemination or disclosure of the trade secrets, such as filing under seal. These types of protections, it's interesting. We've seen the enactment of this legislation in the United States parallels similar legislative activity in the European Union, and these types of protections being made explicit here in the statute mirror similar concerns and debate that we heard and saw in the European Union with their recent trade secrets legislative activity. The other interesting piece here is that the immunity provided by the Defend Trade Secrets Act needs to be disclosed in language included in confidentiality agreements with employees in order to protect the employer's right to recover either exemplary damages or attorney's fees if the employer brings a suit under the Defend Trade Secrets Act for information that's subject to that confidentiality agreement. It's yet another safeguard for the employees. It is worth emphasizing that although the Defend Trade Secrets Act has added some bells and whistles that we've just gone through, and then also, of course, is quite significant in the sense that it opens the doors of the federal courts for trade secrets claims to be brought even where there's no diversity, diversity being previously the principal basis for trying to get trade secrets claims into federal court. That, of course, a very significant development. But I do want to emphasize that the basics of what is a trade secret, what constitutes a misappropriation, and the basic conceptual framework of the law of trade secrets remains unchanged by the Defend Trade Secrets Act. And just to emphasize that point, we've quoted here the definition of trade secret that appears in the Economic Espionage Act, and of course, therefore, is the operative definition of trade secret for the civil remedies under the Defend Trade Secrets Act as well. And we see here pretty much almost verbatim, there are a few tweaks to the language, but almost verbatim the language of the Uniform Trade Secrets Act that's familiar to most of us, that defines the trade secret as essentially any type of business or commercial or scientific or technical information, no matter how created or stored, so long as the owner takes reasonable measures to keep the information secret, and so long as the information derives economic value in part from its secrecy, and the fact that it's not readily available to others through proper means. Those are, of course, the three basic elements of what constitutes a trade secret under well-established U.S. law, and will continue to be the basic elements of a trade secret under the Trade Secrets Act. And this sort of segues to the next part of our presentation. It's Julie had asked that I talk about current developments in the law of trade secrets, and so the Defend Trade Secrets Act, of course, takes the headlines because it's an obvious development. It's new legislation. It's legislation that's several years in the making, and so it's very interesting to talk about. But I would be remiss not to talk about, for at least a few minutes, about another trend that is really changing the way that we approach the protection of trade secrets, and also provide some context for what Julie's going to be talking about next, which is how to, in practice, take appropriate and pragmatic approaches to integrating trade secret protection into the workplace. That other trend, of course, is the really heightened and sometimes it maybe feels like almost hysterical awareness of cybersecurity that has developed over the past couple of years with the succession of headline-grabbing hacks and cyber attacks that have happened both from commercial actors and from social activists and criminals and even state-sponsored actors. The cybersecurity and its the two parts of what fall under cybersecurity, data security and data privacy. Awareness of these concepts and awareness of the importance of maintaining reasonable data security is really changing the way that people think about trade secrets law. at least in its practical application, and it's changing in very important ways the manner in which the courts and practitioners approach one part of the trade secrets definition that is really pretty critical. And it's just to come back to this last slide, it's this question. Has the owner of the trade secret taken reasonable measures to keep the information secret? How that question should be answered is changing with the evolving resources, awareness, and standards for what constitutes adequate cybersecurity. Now, I'll give an example that is a somewhat colorful example that's not that I think illustrates well how changing technology and changing expectations can result in changing standards for trade secret protection. This is the case that I'm going to talk about goes back all the way to 1970, but it's an old case that illustrates this concept very, very well. It's DuPont against Christopher, which was a Fifth Circuit decision from 1970. And in this case, the DuPont Chemical Company was in the process of building a new chemical manufacturing facility, and they were of the view that the design of some of their stills and pipes and other equipment in the factory itself constituted trade secrets. And they went to great lengths to prevent anyone from seeing the pipes and the pots and the boilers and all that sort of thing while the factory was being constructed. So they had fences and gates, and the fences were draped with fabric or were solid, or constructed of solid materials, all to prevent anyone from seeing in, except for workers who'd passed their security clearance or signed confidentiality agreements, etc. So some unknown enterprising competitor or commercial rival of DuPont hired someone to fly an airplane over the factory. And the airplane never actually invaded their airspace. There'd be no question of trespass, and just circled around the perimeter of the property for several successive days. And DuPont sought emergency relief in court, was unable to identify the competitor, but was able to identify, of course, the pilot and the aircraft based on the tail number, and they sought injunctive relief to prevent the pilot from flying overhead. So the court, the defendant, who was the pilot, said that he could not be liable for misappropriation of trade secrets because DuPont, this was one of his lead defenses and the one that made it up to the Fifth Circuit. He said that DuPont had not used reasonable measures to protect its trade secrets because DuPont had not put drapes or camouflage netting over the top of the factory. And that if they wanted, and since they had not used reasonable measures, they had no trade secrets, they had waived their trade secret protection, and therefore he could not be liable. The Fifth Circuit had thought that was an interesting question, but did not have too much trouble reaching the conclusion that it was such an unusual event to have someone fly overhead a factory in order to take pictures that reasonable measures were the reasonable measures standard was satisfied simply by putting up some drapery around the factory so that someone at street level or at foot traffic would have their vision obscured, and that you were not required to take the extraordinary measure of preventing surveillance from the air. The reason I use this case is because expectations about privacy from the air are, of course, changing quite radically now. And as we move into is one area of privacy and security legislation, trying to legislate the use of drones. That same pilot that in 1970 had to use a loud and noisy commercial aircraft in order to accomplish his surveillance now could go to a toy store, purchase a product for a couple of $100s, and perhaps even completely unnoticed surveil the same DuPont factory during its construction process. And so the question that this illustration poses is, well, to what extent do we have to reevaluate cybersecurity or data security for trade secrets in light of the evolving standards and evolving resources and tactics that are being used by the hackers and by companies who are in the marketplace offering products designed to avert those measures? Not going to attempt to answer that question today, but I think it is an interesting segue to the next part of our presentation from Julie on what employers need to be doing in order to cultivate workplaces and workplace environments where managers and employees are participants in a continuing dialogue and partnership in responding to these and other sorts of threats. So, Julie, I'll hand it off to you.
Thank you. Thank you very much, Matt. You know, it's not possible with an hour-long presentation to talk about all of the various laws that may come into play when you're talking about confidential information and trade secrets. We shouldn't forget the long-standing types of claims and protections that are out there based in contract law and tort law with claims like unfair competition, interference with business relationships, and things of that nature. All of those, including the Defend Trade Secrets Act that Matt explained to us, form the basis for what we're going to talk about next, which is how do you embody and develop and protect these rights in your information if you are an employer? What do you do? What legal protections and measures do you have to implement in order to show that you've acquired and obtained or created a trade secret, that you've taken reasonable measures to protect it, and that the employee has an obligation to protect it based on the measures that you've implemented. So we're going to talk about today some of those measures being outlined here. There are different vehicles. Employment agreements are one of the most common, along with employment policies. Separation agreements also can be a very useful tool to accomplish this. Procedures that an employer has in place when an employee is leaving your workforce, which is becoming ever more important along with these changing laws and cybersecurity type issues. And then we have some other suggested protocols that, depending upon your particular workforce and the employee at issue, may be recommended. So let's start with employment agreements. Sometimes we get the question, are employment agreements necessary in every case for every employee? And the answer is not necessarily if you're talking about just a confidential information clause as opposed to a non-compete. But in general, any employee who has access to an employer's confidential information, the employer could benefit from getting this protection in a contractual way. And these days, I would find it hard to envision many employees who would not have some level of access. Of course, there are some, but many employees do have some level of access to an employer's trade secret and confidential information. And so why do you want an employment agreement that has the contractual obligation to protect an employer's confidential information? Well, one of the reasons is to give you another cause of action so that if you do wind up having to enforce your rights legally, you have more than the trade secrets statutes to rely on. You also have a breach of contract cause of action with some of the additional clauses such as attorney's fees that may be available that you can contractually obtain for the employer. And it can also serve as a fallback if some of the information that you are fighting about doesn't wind up being able to obtain trade secret protection, because the definitions can be rigid, and sometimes the information might not be able to obtain that status under the law, and you can fall back in some cases on your contractual obligation. So some of the clauses that are important to include in these confidential information clauses are outlined here. Here are some of the more evolving issues. You know, it used to be that these clauses were never even scrutinized and never really brought to issue very much, but these days that's changing. We've seen some activity where courts are looking more closely at over broad definitions of confidential information, and so the old any and all information relating to the organization is not likely to work as well anymore. So one of the things you can do is to try to better define what actually constitutes your confidential information and group them by as many categories as you can and as many descriptions. Depending upon your jurisdiction, another factor under some state laws is to require a temporal restriction for information that is not going to meet the definition of a trade secret. If something's a trade secret, you can protect it forever. If it's not a trade secret, there are some courts that are looking for temporal restrictions so that you have a period of protection for so long as the confidential information remains confidential or valuable. It helps, of course, to have the recitals acknowledging why this employee is being asked to be obligated to these restrictions, detailing the level of access, the job descriptions that the employee is expressly asking to be given access in order to perform his or her job. And then finally, of course, we feel the need to mention here in Illinois we have this 2-year rule handed down by the Fifield decision a couple of years ago. It's unclear how or if that 2-year rule is going to be applied or would be applied to a strictly information-based restriction. The 2-year rule being that an employee has to be employed by a company for 2 years before a restrictive covenant, a post-employment covenant, could be enforced against that employee. The case that dealt with primarily with a non-compete restriction, and we have yet to really see how that is going to be applied in a situation where just a confidential information restriction is at issue. Another thing that can be addressed in employment agreements is departing employee obligations. So these are going to come in various different places in your agreement, not necessarily all in a paragraph that says departing employee obligations. They would be placed where appropriate and applicable. But these include, these days, what is really almost becoming a necessity, certainly for higher level employees with great levels of access to information. Inspection of personal devices that the employee has used for work in order to remove and scrub any protected information that belongs to the employer. Of course, you want to obligate the employee to return any information that they are aware of that is in their possession. The agreement to participate in an exit interview, in some cases this is being observed to be a necessity for an employer to show that they've taken reasonable measures to retrieve and protect their information. So to have that agreement in writing, that the employee agrees to sit down and talk with the company and make sure that these post-employment obligations and return of information measures have been complied with can be helpful to have in writing. Many agreements, if appropriate, can have the obligation that the employee notifies his or her subsequent employer of the confidentiality obligations for a period of time. That probably should not be an indefinite obligation, but for a period of time after employment, that can be some protection so the future employer knows that there's this contract sitting out there. Another helpful clause that we have run into here in the employment law world is it sure would be nice to know where the employee is going if this initial employment doesn't work out, if they're at a subsequent employer for 6 months and then they jump ship and go to another employer, which may directly implicate and jeopardize some of the confidential information and trade secrets. It's helpful and useful to have a requirement that the employee notify the employer of all employment held within a specific period of time, again, and that would need to be reasonable and information-based. The inevitable disclosure-based restriction can be a creative way to try to get around some of these non-compete protections that many states have in favor of employees. It might not pass muster in all jurisdictions, but it's a kind of clause that says the employee agrees not to work in any capacity that will require disclosure or inevitably result in disclosure of the employer's trade secrets or other confidential information protected under that agreement. It's it's a runaround against a straight non-compete, making it a strictly information-based restriction. The invention assignment clauses are sort of an offshoot of this kind of information protection. In addition to addressing inventions and patents sought during employment, it's helpful to have, again, a notice requirement saying that, if the employee is seeking patents after employment for a period of time, that the employee be notified of those patent applications so they can review them to see if it's based on confidential information where the employer would actually have a right in those patents. And I've seen some helpful clauses that authorizes the company to actually act as agent for the employee to assign over to the company inventions if the employee has not acted in compliance with the agreement during employment. Those can be helpful tools in some limited types of situations. Another clause in employment agreements that can be that's highly recommended in this day and age is the employee's agreement on how he or she will use the company's electronic information and systems. These are fairly standard these days. The agreements should set out, not only these 4 bullet points here, but those agreements and those clauses, depending upon the industry that the employer is in, can get to be quite lengthy. But they should include, certainly at a minimum, that the employee has no expectation of privacy in the company's electronic information and systems and use of company devices to work with it. The employee would be prohibited from installing his or her own software or programs onto employer devices without the company's prior approval. That there will be no non-company related use of the company's information for the benefit of any other entity or individual without the company's consent. And then a statement addressing the level or extent to which download, access, or saving of company information on personal devices might be permitted or prohibited. Again, and that would be specific to your industry and your employee group, I would think. Bring your own device clauses are becoming more and more prevalent these days. These take some different forms, but some of the more common aspects of these clauses include what you see here, that if employee is using his or her own device to do work, that the company reserves the right to monitor content and information that is on that device when it comes to the employee's performance of work. There can be data encryption and password protection requirements, again, for the protection of any employer trade secrets or information that is housed or used on the employee's personal device. If the employee leaves or if the device is lost or stolen, that the employer would have the authority to wipe the data, any work-related data, which may or may not result in wiping of personal data as well, even if the company uses best efforts not to do so. And if the device is lost or stolen, the employee should be required to notify the company immediately so they can take steps to protect the information on that lost or stolen device. The employer should be able to inspect the device upon a request, such as in the context of an investigation or a complaint of some sort of internal wrongdoing. They may have business reason to need to inspect the device. And more and more, there's installation of certain software that the company deems necessary to protect its own information that the employee may need to consent to in order to continue to use the personal device for work-related reasons. Matt mentioned this earlier, but increasingly a more important aspect of employment agreements may be inclusion of this notice under the Defend Trade Secrets Act. So if there is a confidentiality clause, then the DITSA notice should be included if the employer later may want to avail itself of exemplary damages and attorney's fees that that would be available under DITSA. And note that this requirement to provide notices is quite broad. It applies to any contract that addresses any confidentiality obligations of the employee. An employee includes independent contractors and consultants. It's not just limited to an employee. So I think for practical purposes, we need to read that to say any individual where the employer is requiring an obligation of confidentiality. And here's the requirements of the notice here in the bullet point 1, 2, and 3, but no need to immerse yourself in that in great detail because here on the next page is a sample notice. This is actually the short form. There's a much longer form in different ways that you can present this to an employee to make it digestible, but this is the most condensed way that we here in the Labor and Employment Group found to sort of provide this information that was on the previous slide. So those are some of the main vehicles available when you're talking about employment agreement protections. Turning now to employment policies, which would be in an employee handbook that the employee is given at or during employment. Now, of course, employment policies, for the most part, are not going to be enforceable against an employee after they leave. It's not, for the most part, a contractual obligation, either by the company or the employee. But the policies can be very useful for a number of reasons. They, first of all, set expectations for the employee during employment, so the employee knows what is expected and what would be considered a violation of those expectations. They support disciplinary measures during employment if someone were to violate protocols relating to confidential information. And they also help to demonstrate reasonable measures. Again, we're always looking to be able to demonstrate that the employer tried to protect its information in a reasonable way in order to get that trade secret status. So some of the policies are listed here, and in large part these repeat the clauses that we discussed that may be included in the employment agreements, but these deal, again, with confidential information, use of company electronic information and systems, a standards of conduct policy, which more and more these days perhaps should include performance in complying with information security rules. Performance evaluations also can include a component on how the employee has complied with information security. Handbooks should provide notice of electronic monitoring, again, to preserve that ability for the employer. And finally, there should be a policy in there. Again, we recommend that an exit interview be conducted, certainly with employees with higher levels of access to information. Separation agreements also is sort of your last chance to get some of these obligations in writing, and oftentimes separation agreements sort of buttress the obligations that are provided for in the underlying employment agreement. Sometimes there is no underlying employment agreement, and so you can use a separation agreement to try to get some of these affirmations regarding the protection of confidential information. The provisions regarding protection and non-use of the employer's information can be deemed a material term in the agreement, and possibly, depending upon the situation, maybe even requiring a clawback of any severance paid for proof of a violation. Keep in mind, though, that if you're seeking an age waiver under the Age Discrimination and Employment Act, usually separate consideration is going to want to be given for that. That's not subject to clawback in order to protect the age waiver. The separation agreement also can be an opportunity to provide the DITSA notice if you had an underlying employment agreement that did not. Now, again, this law is so new, this has not really been tested yet, so the sufficiency of after-the-fact notice is unclear, but there might be no harm in including it in there in the hopes to argue that the employee was actually provided notice, even if it wasn't contemporaneous with the original confidentiality application. And again, these separation agreements, if the employee's next employer is known, they can include affirmations that the new employer has been notified of the pertinent confidentiality obligations. Some protocols and practices for departing employees can be a very good idea, particularly with some employees. You know, the level to which a company might want to implement these is going to change. If it's a lower level employee with no suspicious activity and no reason to be concerned, this would be overkill. But in some cases, you might want to think about doing these things. Certainly an exit interview is going to be a good idea in virtually all cases. A review of recent email traffic may be warranted. Imaging of computers may be warranted, especially if suspicious activity or wrongdoing is suspected, as would the fourth protocol here, which is freezing the computers and the hardware and devices for a period of time rather than recycling them right away. If you have the supply and the bandwidth and the stock to do it, it might be a good practice, because sometimes you don't know if there will be an issue when the employee is walking out the door, and it's only 6 months later that you realize there could be an issue here. So if you have the ability to do it, that's something you can do to be able to protect evidence for a later date. And here's some other suggested protocols. Many, if not all of these, are routinely in use at employers these days, but they're the typical password protection, a user-based access to information so that your more sensitive information isn't available to your entire workforce, but only to those with need to know for their jobs. Electronic monitoring with notice and used in a consistent and non-discriminatory manner or based on reasonable suspicion, and some of these other measures. We say here that a suggested protocol is to keep in mind that how and when and the consistency with which these contractual obligations are enforced is looked at. It can be looked at in future litigation, meaning that if an employer doesn't enforce them in any case and then decides to enforce them in one case, that can be seen as selective enforcement that defeats the employer's having taken reasonable measures to protect the information. Having said that, these cases are fact-specific, and if an employer chooses not to enforce it with an employee who had little access with no suspicious activity, that's a situation that could probably be distinguished from another situation where the employer has reason to believe that enforcement is necessary. So it's just an issue to keep in mind as you're making decisions about when and whether and how strongly to enforce these obligations. So that concludes the part of the program discussing some of these employer tools that are available. And what I thought we would turn to now, and Matt and I can chime in together, is a discussion on how do you get employee buy-in? Because it's important, first of all, to get employee buy-in in order to have an effective policy that's implemented workforce-wide. And it can also be a hard task to accomplish, because I think we all realize that these can be a little bit cumbersome or off-putting to be handed when you're onboarding or during employment. And depending upon how they're drafted, they can appear to be difficult to follow. So one of the first steps that I think we can suggest here is to implement reasonable policies that are easy to digest. That's going to be a first step toward making this accessible to employees. And a communication of the importance of these policies, that an injury to the company's trade secret or confidential information security is harmful to the company, and in turn has the potential to affect all employees and the health of the company. And to communicate the message that it's not a victimless crime. I think that in some situations employees might see this as they don't really understand or perceive that there's an actual harm done. And to communicate the message that it's a serious security breach, in some situations it's analogous just to walking into someone's home and stealing their prized possessions. This would be taking an employer's most prized asset and walking out of the company's doors with it and then trying to do harm to the employer. if employees receive and understand that message, they may be more receptive to doing what's necessary to protect the company. And then finally, when it comes to employment agreements, there's a quid pro quo that's offered in these agreements. Some, or that can be offered. Some agreements are just at-will employment agreements with these confidential information and possibly non-competition provisions, but they don't have to be. You can consider really offering a material and tangible quid pro quo in exchange for their promises to protect information, and that might speak louder than words.
The piece I'll add to that, Julie, is that, and I think this is a nice lesson that we can learn from the cybersecurity context. One of the things that employers have struggled with in the cybersecurity context generally is just the challenge of workarounds. That is that, the good news is many of our clients have really smart, really talented, really creative employees. The bad news is that those really smart, really talented, really creative, really independent employees want to get their jobs done in the most efficient and practical way possible. That creates the problem of the workaround, which is that there has yet to be invented a data security policy or practice or hardware or system architecture that can't be bypassed or frustrated by an employee who's simply well-intentioned in trying to get their job done, but just doesn't like the restrictions that are being put on the employee because of the in the name of data security or data protection. And so, getting that kind of the part of the challenge that I think has to happen here is that the policy making and policy writing has to move out of the cubicle or office of an individual employee who's tasked with handbook management and turned into a more iterative process that becomes a dialogue between the manager of each of the relevant, or managers of each of the relevant departments, the people who are the stakeholders in the sense that they're the people who actually have to get the work done, and then your risk management personnel, whether that be human resources or legal, or your information technology or information governance folks. And that type of dialogue is important, one, because it will create more robust policies, and then two, because if people understand how the policies were developed, why they were developed, and feel like they had a voice in the process, then you're much more likely to get the sort of buy-in and commitment to the policies that will help deal with the workaround issue.
We have about 5 minutes left in the program, and I'd like to invite the attendees to submit written questions. And while you're thinking of questions that you might want to ask, I was hoping to ask Matt, in addition to the Defend Trade Secrets Act, which is the newest kid on the block, we often get questions about the Computer Fraud and Abuse Act, which is the one of the other federal laws that many of us have heard a lot about. And I'm wondering, Matt, if you could just give us a couple of minutes on the Computer Fraud and Abuse Act and why we don't see that being used more often than we do.
Yeah, I would say that the Computer Fraud and Abuse Act offers sort of a cautionary tale as we approach the Defend Trade Secrets Act. The CFAA is both a criminal and civil statute. Just like the Defend Trade Secrets Act has been engrafted onto the Economic Espionage Act. And when a civil remedy was created under the Computer Fraud and Abuse Act, I think the Congress had a entirely laudable objective there, which was to protect American companies and American employers from theft and hacking and also sabotage of their valuable computer networks and the data on those networks. The problem arose because some creative advocates who saw the Computer Fraud and Abuse Act as a way to grab a federal cause of action and an opportunity to bring litigation in the federal courts that typically would end up in the state courts, especially non-compete claims. And so there was a trend for a few years where almost reflexively employers were adding a CFAA claim alleging that a departing employee had exceeded authorized access or had engaged in unauthorized access in the employer's networks, computer networks before departing, based on the theory that any access of company data that was used for a purpose other than the employer's best interest, in other words, downloading or copying files before the employee leaves with the idea of using them in some way in the subsequent employment, that somehow that violated the CFAA. That theory is not completely dead. There's a circuit split, and so it is still a viable theory in some courts, but the cautionary part of this is that I think we do have to be careful as a bar as to how creative we get with the CFA with the Defend Trade Secrets Act, and to exercise a little self-restraint in how many cases that truly belong in state court we try to drag into federal court just because we think we can, because it does end up. Some of the case law that came out of the CFAA with the court's efforts to try to make sure that it did not become a gateway for essentially a deluge of employment claims into the federal courts, ended up, in my view at least, working a little bit too hard to narrow the CFAA, and ended up, I think, narrowing some protections and out of or reading some protections out of the statute that I think we would have preferred to have kept for employers, at least in those judicial circuits that have taken that approach.
Thank you, Matt. I don't see any questions, and so Tammy, I will turn this back to you.
Okay, thank you. That completes our presentation for today. We hope you've enjoyed protection of employers' confidential information. For CLE purposes, please click on the evaluation link now displayed on your screen and complete the certificate of attendance. Please allow 4 weeks after the program to receive it. Thank you for your participation, and we look forward to having you back for other events in the future. Have a wonderful day.